Mariano Rendon Jr.
Yes, Judge, I've filed notice of appearance as additional counsel. Mr. Bloomquist is aware. He was anxious to accept the plea agreement as the state had offered him. Larry's in trial in Comal. And so I'm just here to, well, I'm new on the case, but we want to delay the process with doing the substitution. So he just let me do the additional counsel notice.
So in the indictment, it has him down as Mariano Rendon, but then in all the plea paperwork, it says Mariano Rendon Jr. Is he a junior?
Yes.
Okay. All right, the court is calling 2024 CR 2339B, State versus Mariano Rendon Diaz. I'm sorry, Mariano Diaz Rendon Jr. Do I have parties announced?
Raymond Martinez for Mr. Rendon.
And are you Mr. Rendon?
Yes, Your Honor.
All right. Have you had a chance to meet with Mr. Martinez?
Yes, Your Honor.
Do you have any objections to his standing in for counsel?
No, Your Honor.
And Mr. Martinez, did you speak with his counsel?
A couple of times, Judge, and earlier this week, I explained to him he would be set today, and he related he didn't know when he could come in and do the plea because he's in trial in Comal, and he may go into next week.
All right. Counsel, have you received all discovery?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Rendon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rendon, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
All right, off the record for a moment. So he was sentenced in another case, correct?
Right.
So,
Same incident, different charge.
all right, so in that case, he received prison time?
Yes.
So he wants to be in prison, then come out on deferred?
That's the offer the state's making. He wants to close out his case. He doesn't want to stay here waiting to try another case. This is the same offer the co-defendants have received. He's okay with it. He wants to go service time, and then he's willing to do the probation.
So how much time did he do? How much time did he receive on the other case?
3 years.
3 years. So do y'all want him to go to prison, then come back out and be on deferred?
I believe that is the state's intent.
Okay. All right. Okay, thank you. Did you review that? I'm sorry. Oh, we're still. All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I give you all.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's an affirmative finding of deadly weapon. The state recommends deferred adjudication. There's to be no contact with the complaining witness, anger management, MRT, and TAP. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 200 hours community service restitution, no contact with the complaining witness in a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection, Your
All
Honor.
right, states you may be excused. Did you review the waiving stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachment, all right, could I have a 30-day reset for a contested hearing, please?
August 14th.
Judge, I have my vacation letter for the month of August,
All right, so when will you be back?
September.
All right, Norma, if you'll put it for September. And I'm gonna alter and amend his conditions of bond. I don't know if as a part of his conditions of bond, it's no driving, but I'm gonna add no driving to your conditions of bond.
September 8th.
And did you drive here today?
No.
All right. We can go on the record. Court is calling 2024 CR 1737 State versus Mario Alberto Vargas. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Robert Valdez for Mario Vargas, Your Honor.
And are you Mario Vargas? All right. So there's been an agreed setting for a contested hearing of September 8, 2025. Mr. Vargas, I don't take any of the allegations in your motion as true. However, I do have to set conditions that I believe will protect the community. So I'm going to order as a condition of your bond that there be no driving. Do you understand?
Yes, sir.
All right. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thanks, Judge.
Thank you. Good morning.
Thank you. State is recommending the progress solution. Okay, thank you.
All right, thank you. Feliciano Mora. All right, is this on the docket today?
It is, Judge.
All right. Hi, Mr. Mora, how are you doing? All right, so Mr. Mora. In court, you're not allowed to wear shorts. Those are not my rules. No.
I'm sorry.
No. Here's the thing. I always say that if you don't know beforehand, then you don't know. So I would always tell my clients, you don't need to get a three-piece suit. If you have some jeans, not the ones that the fashionable ones that they rip, that will be fine. Okay? All right, so counsel.
Judge, even though it's an old case, it's actually his very first appearance in court on these cases.
Mhm.
I have reviewed the files. He and I have discussed the case. We need to review it for potential motion to suppress. So
Okay.
whatever your next normal setting is, fine with us.
All right. So do you have all discovery?
It looks like a judge, yes. Yes.
And you're gonna want a motion to suppress?
Well, I want to double check. I need to watch the videos to see if it corroborates what they say in the report. That's really the big issue.
All right. Did they tender an offer to you?
Not today, Judge. I'm not ready to ask for one until I know whether or not I have any defenses to.
All right, Norma, if I can have a 3-week reset on this case?
July 31st.
All right, we're gonna come back on July 31st. At that time, the state is going to need to have tendered you an offer.
Understood.
Once you sign the reset form, you are excused. And thank you for being on time today.
I read that the class is doing, I've been doing this class, you guys,
Okay,
and I'm like halfway done.
okay, awesome.
Actually, like 15 days that should be done.
All right, and so has it been helping you?
It's not pretty cool. Like, I'm actually trying to be a member of that, you know, to
Mhm.
be a, you know, it's pretty cool. I haven't done it in years, but
Mhm.
that's pretty cool. I've been going twice a day because I like, you know.
All right, that's
keep-
awesome.
Keep out of the work over there.
Mhm. Oh, that is awesome. I always think it's nice when you're able to meet people who are trying to improve, like you're improving, and then they can give you tips and you can call
I
them.
even take some of my friends and nephews with me because I'm like, oh, you gotta be serious. This is pretty nice, you know that.
Some,
Get into it.
okay, I'm glad it's working for you.
I like.
All right, all right, have a good one, okay?
All right, let's talk about that. This hearing for Mariano Rendon Jr. was a good illustration of how even serious cases can be handled with steady professionalism when everyone comes prepared. Mr. Rendon entered a no contest plea to aggravated assault with a deadly weapon, and while that's always a charge that gets attention, you could see right away that this was an organized, almost methodical process. Judge Boyd kept the tone calm and measured throughout. The first wrinkle was clarifying Mr. Rendon's full name. Some documents called him Mariano Rendon, while others said Mariano Rendon Jr. Once that was sorted, the rest of the plea colloquy moved forward without any real bumps. Defense. Counsel stepped in as additional counsel rather than fully substituting, which is pretty common when lead counsel is stuck in another trial. To their credit, both attorneys had obviously communicated ahead of time, so there was no scrambling or confusion about the plea terms. Mr. Rendon himself was polite, clear, and engaged. He answered every question with a respectful "Yes, Your Honor," and didn't seem evasive or confused. What stood out most was that this plea was structured to let him serve a 3-year prison sentence on another related case before coming out on deferred adjudication for this one. It's an unusual sequence. You don't often see a defendant finishing prison time and then rolling straight into a probation period, but the state explained this was the same offer his co-defendants had received, and everyone agreed it was the cleanest way to resolve all charges without prolonging things further. Judge Boyd went step by step through each right. Mr. Rendon was waiving jury trial, confrontation of witnesses, the right to remain silent, and confirmed multiple times that he understood if probation were revoked, he could be sentenced to up to 20 years in prison. Mr. Rendon never wavered. He acknowledged that nobody had threatened him, that he was satisfied with his representation, and that he wanted to accept the plea. The state recommended 5 years deferred adjudication with significant conditions: 200 hours of community service, restitution, no contact with the complaining witness, anger management, MRT, and a TAP evaluation. The court made sure he knew these were recommendations and that the court retained discretion. While it's a hefty set of obligations, Mr. Rendon didn't express any hesitation. He was ready to get this part of his life moving forward. What struck me was how even in a serious assault case, the process stayed professional and even-keeled. Nobody tried to dramatize the situation. Judge Boyd's questions were thorough but never condescending, and she closed by setting the next date for a contested hearing in September and adding a condition of no driving. Overall, This hearing was a solid example of how a serious plea can be handled in a way that's respectful to everyone, victims, the community, and even the defendant. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,